Faces and chapters from the Central European legal heritage. Welcome to the Central European Legal Insights, the podcast series introducing the professors of the Central European Academy at the University of Miskolc through insightful conversations with Judit Varga.
And I would say that the projects of Central European Academy can help each of our nations to put in the first plan our national identities and our national peculiarities. We are all part of the same Europe, we are all part of the same community, but we have our strong national identities, and that is something that we have to be proud of. I would say that in all of the countries of Central and Eastern Europe, including Croatia, this search for constitutional identity was especially provoked by the EU law. I would say that the European Union, from its beginnings, still is a sui generis community of member states that is and was through time moving slowly towards some federalist framework, but never got there.
Welcome to Central European Legal Insights, the podcast series of the Central European Academy at the University of Miskolc. My name is Judit Varga. I work as a senior mentor at this academy, and I will be your host in this podcast. In each episode, we would like to present the faces and the personalities of the Central European Professors Network, and we would like to bring you closer to the very rich diversity of Central Europe's legal heritage. But also, we would like to explore the stories and ideas beyond science that connect us in this region. I warmly welcome in Budapest, in the studio, Professor Dr. Petar Bačić from the University of Split, and he is a constitutional law professor, and he's a long-standing cooperation member of this professors network of the Central European Academy. Mr. Bačić, I'm happy to have you here.
Oh, thank you very much for welcoming Dr. Varga. It's a pleasure to be with you here today.
As we already had many podcast episodes, we would like to present the true faces of the Professors Network. So today you are presenting Croatia and the legal science of Croatia, especially Split, coming from a university which is at the coast. For us, sounds very specific, actually, for a country where there are no seas. How do you feel the difference teaching at university at the seaside?
Yeah, it is true. I come from Split, a beautiful city at the Mediterranean coast. I live and I teach at the Faculty of Law in Split for 25 years now. I'm a professor of constitutional law. Besides constitutional law, I also teach EU public law as well as human rights law. So living at the Mediterranean coast, I would say, is a blessing on one hand, but I always say to my colleagues, especially from Western Europe, that because of the weather and the sun, you have to appreciate our achievements even more, because it's not easy to stay inside and not to walk by the sea in the office. Yeah,
I can agree. For me, the Croatian coast is in connection with the holiday feeling. So my great appreciation for your valuable track record in your professional career, and you are a real long-standing partner in this Central European Academy, and this is why we would like to tackle very interesting issues based on your contributions, ranging from federalism, European law, supranational trends, and also the role of the national parliaments, which are also reflected in many of the PhD research programs of our students at the academy. But in order to warm up a bit, I would like to talk about your legal background, your personal background. Why did you find it appealing to choose academic career to other traditional legal careers like attorneyship?
Okay. Well, I was born and raised in Split, and it was a kind of a family tradition. So there are many lawyers in my family. I'm just one in the line. That is true. I finished my studies in Split. Then I did my master thesis in Zagreb. I did it in public international law, and then again in Split. So that was kind of a logical choice for me. Sometimes I'm thinking, would I choose the same if I had the opportunity? And the answer is almost always yes.
So you are a happy and satisfied person.
I am happy, definitely with my job. I can say that.
We already touched upon the Mediterranean coast issue, and we are here the Central and Eastern European Professors Network. But you also have another leg in the Mediterranean area, and I assume there might be some differences in the concept of the Mediterranean priorities areas. Do you feel this difference when tackling Central European issues and also Mediterranean legal issues?
I understand the question, and I wouldn't say that there are many differences when it comes to that. When we tackle legal issues, then I would say that we are pretty much on the same ground. So when it comes to that, I don't think that living on Mediterranean adds anything different to that aspect.
But sometimes we say that in Central Europe we speak the same language, we have the same traditions, especially being ex-socialist countries.
Exactly.
But the Club Med, the Mediterranean Club of the European Union, also includes those member states who never experienced this historic era. So in this sense, do you also belong to another club? Being a Mediterranean, having a Mediterranean coast as well, do you feel any difference in priorities or values, etc.? Like you deal with maritime legislation.
Yeah, when it comes to that,
which is a specialty of that
absolutely.
region.
When it comes to that is something that my alma mater, Faculty of Law in Split, was. I would say recognized for, because we started in 80s with a PhD doctoral studies which was devoted to maritime law and law of the sea. It was a master studies, quite good and interesting and quality program at its time. So definitely, yes, that is one part that we have in common. And when it comes to that, I might add that quite recently my University of Split, entered into an alliance of University of Seas, which connects now, I think, if I'm right, 9 universities all across the Europe. And the main connection between them is the fact that they are all coastal cities.
Oh. Could you just name one of those partners?
Yes, it's Cadiz, it's Cadiz, Gdańsk, it's Napoli, Naples, etc.
Sounds very exciting.
Yeah, it is.
And what is your story with the Central European Academy? How did you get in touch with us? How did it happen?
Okay. I think for me it started back in 2022. My first project with the Central European Academy was a research on COVID-19 and what we might call the emergency constitution. So I did my research. That was my first experience. And after that, I realized that under the auspices of the Central European Academy, there is really a variety of programs and research. So easily time, step by step, I started to be more engaged in
and you
more
also
and more
recommended for your students, because I do know that you also have a student in the PhD program.
Absolutely.
Of the academy.
Now, in fact, I have 2 students at the PhD program. One is on the 4th year, so she is, I would say, Nikolina Barasovic. She is approaching her final stage of her PhD dissertation. And the other one is Bruno Boban, coming from Split as well. He just enrolled at the academy.
And what is their feedback? Do they enjoy being?
Their feedback is... I would say exceptional, because they not only enjoy living in Budapest, but they also endeavor the Central European Academy as a hub that connects so many young people from all over the Central and Eastern Europe. So that international spirit that's all around at the Central European Academy, I would say that's the best thing and main advantage of that PhD program. And when it comes to that, I would say, in my opinion, that is probably the most attractive program that CEA offers. Why? I always remember the time when I was studying law. That was from 1994 to 1998. So the war was still going on in Croatia, and there were so little opportunities for students to go abroad. So I always encourage students to use possible arrangements and ways to study abroad, and this was and still is an excellent opportunity, at least in my opinion.
I'm very glad to hear that. Our objective is also to be at least as attractive as the Budapest or Miskolc-based university, like a destination for expert students like the Western universities, because we can offer the same quality services. But here in Central Europe, in the heart of Central Europe, they can still feel at home, although they are abroad. So this is also a policy of the Central European Academy. While I was preparing for this podcast, I was listening on YouTube to one of your presentations earlier given in the framework of our conferencing on the Federalist Union concept, which is among many one of the buzzwords of those thinkers and legal scholars who are dealing with European law or the collision or the question and sometimes tensions between national and European law. Do you agree that the European Union is a sui generis type of union, or is it's like a federalist state in the making? Yeah. What would you comment on this?
Yeah, it is one of those big questions when it comes to the nature of the European Union. I would say that the European Union, from its beginnings, still is a sui generis community of member states that is and was through time moving slowly towards some federalist framework, but never got there. For someone coming from Croatia, as I am, I could say that Croatia itself has a rich experience of living in, let's say, compound entities. It suffices to look only at the 20th century, because in 20th century until 1918, Croatia was part of the Austro-Hungarian monarchy. Then started from 1918 until 1941, it was part of first state and then kingdom of Serbs, Croats and Slovenes, and then Kingdom of Yugoslavia until 1941. And then after the Second World War, we had 45 years of experience of Croatia being a federal unit inside the socialist federal structure of Yugoslavia. So in that sense, Croatia has a rich experience in federalism. Approaching Euro-Atlantic associations was one of the primary goals for newly established independent Republic of Croatia from its beginning. So realizing its goals, first through association with the Organization for Security and Cooperation in Europe, then becoming member of the European Union, then in 1996 becoming member of the Council of Europe, and finally becoming a still newest member of the European Union.
And do you think that the European Union is a federalist state today, or is something?
I don't think that European Union still did that decisive step towards being federation. If there is some kind of federalist stance in European Union, it is maybe best to be described as the cooperative federalism based on the principle of subsidiarity, which is maybe may discover the true meaning of the united in diversity. Yeah, exactly. Because on one hand, it lives thanks to the subsidiarity principle and thanks to becoming the constitutional principle after the Treaty on European Union. It leaves enough space for its member states to express their political goals.
And during the accession process of Croatia to the European Union, I assume that those experiences from the constitutional and independence point of view were all used by those negotiators on behalf of the country, like having in mind what does it take to be independent within a union, and whether it is well safeguarded in the future setup of the membership.
Absolutely, you are completely right when it comes to that. We are all familiar with the thing that Croatian negotiation process took very long. It started back in 1999, in 2000. It lasted all until 2011.
Under the Hungarian presidency?
Under the Hungarian presidency.
This is one of the greatest achievements of the first Hungarian presidency.
Exactly. This is one of strong connections between Hungary and Croatia. Not the only one, definitely.
And in the European Union, in diplomatic circles, this kind of tie, this bond, is still tangible, let's say. So it helps also diplomatic cooperation based on this success or achievement. And then it was in 2013 when you finally...
Yeah, exactly. It was 1st of July 2013 when Croatia became the then 28th member. It is still the newest member state of the European Union, but it's of course now 27th member comes to that because of the Brexit.
Actually, and thanks to the Croatian language, we have 24 official languages in the European Union.
Yeah.
Actually, I do remember that time because I had been working in the European Parliament between 2009 and 2018. So during this time, you had the completion of the accession. And this is how in the cabins of the interpreters, the new abbreviation for the Croatian language just appeared in the hemicycle and in the conferencing hall. Let's move to the more, or for me, the coup de cœur, so my favorite topic, the constitutional identity. And we can also say that the constitutional identity issue is one of the core elements of the Central European Research Network, because we are proud of each other's constitutional identity. Of course, among others, among many, we are the most proud of ours, but we respect each other's national values. This is how we can respectfully cooperate. So in the followings, we would like to talk about the Croatian constitutional identity. You are a professor of constitutional law, so maybe you can put this whole idea into a historic or into a more regional framework, how we have to approach the constitutional identity of your country. I would give an example. For Hungarians, the freedom is the core element of our constitutional identity. And this is how we start our thinking about the present challenges, what we are facing when it comes to the foreign policy or the European Union relations. So let's dive into the constitutional identity.
Okay. Yes, when it comes to the constitutional identity, it is a question of huge importance for each member state, and in Croatia it is the same. The Croatia began its search for its identity back in 1990-1991 with the adoption of first democratic constitution, of course. When talking about Croatian constitutional identity, and the constitution, it is always necessary to take into account the fact that unlike many or most or even all Central and Eastern European countries, Croatia did not have that good fortune to experience Velvet Revolution, unfortunately, because the war was going on until 1995, and it was until 1998 that the whole reintegration of the whole state territory was completed. So that's something that one always has to take into account when discussing this period. As in most European new democracies of the time, Croatian constitution makers tried to establish a state on completely different principles. So moving away from the old regime and adopting new constitution based on rule of law, based on values of constitutionalism, of human rights and fundamental freedoms. And the expression of that is found in different articles of our constitution. Already in its preamble. The preamble of the Croatian constitution is, we might say, a curiosity in the world of constitutionality, because preambles are usually seen as texts which are separated from the normative part of the constitution. In Croatian constitution we have a little bit different situation. It is that part is already numbered, so our constitutional preamble is already first part of the constitution. Then it is also unusual that preamble have their own special titles. The Croatian constitutional preamble has. It's called Historical Foundations, and in these historical foundations we can trace Croatian statehood from the beginning until 1990. What is important for constitutional identity in the constitutional preamble is the fact that already there the constitution maker tried to define the state, and it is stated, it is defined as state of all Croatian citizens, be it members of Croatian nation or members of national minorities who are its citizens. It was of huge importance back then in 1990, and it is still very important for Croatian modern state.
Do you think are there any divergences or parallels between the approaches in the region towards constitutional identity, having in mind the Hungarian, the Polish, and the Slovenian?
I would say that in all of the countries of Central and Eastern Europe, including Croatia, this search for constitutional identity was especially provoked by the EU law, and usually high courts, constitutional courts or supreme courts were the ones who started to discover these elements of identity in national constitutions. The same thing was with Croatia, because Croatian Constitutional Court starting from, if I'm right, 2011, 2012, started to identify these elements of identity in the constitutional text. It started with a definition of state exactly, and with defining what does we the people mean in Croatian context. It is exactly all Croatian citizens.
Respect towards constitutional identity comes from the word of the European treaties, because Article 4 prescribes that each member state and the Union itself respects the constitutional identity of the nations. And for us, this is a very important reference point when we are trying to defend our constitutional values, which is also the content of the motto "United in Diversity," because this is how our diversity can be described. And sometimes I ask professors to define the constitutional identity, because this is the first step in order to agree on what we mean by constitutional identity. Do you have an answer for that from your...
Yes, based on the Croatian constitution, I would say that the very essence of Croatian constitutional identity is first of all embedded in Article 3 of the Constitution that highlights the highest values of Croatian constitutional order, started with freedom, equality, rule of law, etc. That is the very essence of the Croatian constitutional identity, combining with the definitions of state in Article 1, which defines Croatia as democratic and social state.
And what is the role of the Constitutional Court in defining and fine-tuning this meaning? Because then cases might come up during the membership when there might be some kind of collision between domestic legislation and European, and the question of supremacy of European law. It's also an overly tackled issue in the European Union. Do you see any best practice of the Croatian Constitutional Court where they elaborated a methodology or a good recipe how to approach these challenges when the ever-growing European legislation tries to interact with domestic legislation? And there might be individual cases where this theory should be applied in practice. Are there emblematic cases or any recipe or methodology or specificity of the Croatian Constitutional Court?
The Croatian Constitutional Court started to be more engaged in judicial dialogue, especially using the preliminary question procedure.
Yeah, that's a very good tool.
Yeah, it is.
And always checking
absolutely.
The boundaries.
Absolutely. Although it was reserved, in Croatia, lower courts started with opening this dialogue with the European Court of Justice, and the Supreme Court and Constitutional Court were reserved. However, in recent years, they started to ask questions. It's still not a huge number, but it's something to begin with.
So they are very active, the lower courts, not the Constitutional Court?
The lower courts were more active than high courts.
This is the state of play, I think, in every member state. But when it comes to crucial questions of principles, questions of national identity, the final say is usually with the constitutional courts. Like in Hungary, a very emblematic case on migration, we had a very recent and important milestone case issued by the Hungarian Constitutional Court a couple of years ago. So in this respect, do you also see or foresee such milestone cases in Croatia?
Absolutely. Constitutional Court has to take the responsibility in further elaborating Croatian constitutional identity. Such cases will occur. That's for certain.
And I have a colleague who described the meeting point or this phenomenon, the ever-growing tendency from Brussels to intervene into domestic issues with European Union legislation, like an unstoppable object would meet or would hit a stable stone, a stable rock. The stable rock is the national constitution, and the unstoppable power, the unstoppable trend is the European Union and the supremacy concept of the European Union law, which is highly debated also among the constitutional lawyers and in this international constitutional dialogue. One of the most interesting and exciting issues. But coming back to Croatia, there was an amendment of the constitution in 2010, and as far as we see it, it might play a key role in aligning the European norms or Croatian norms with the European standards. Which amendments, in your view, had the most significant impact on constitutional identity in this constitutional reform of 2010?
Okay, so from its adoption until now, Croatian constitution went through or was amended on 5 occasions. It
since
happened
1990?
Yeah, since 1990. The first, each of these constitutional amendments had its own special reasons or justifications. So in 1997 we had the first constitutional revision, which primarily tackled the Constitutional Charter of Rights, because at that time Croatia had to align its Constitutional Charter of Rights with the European Convention on Human Rights and Fundamental Freedoms. Then in 2000 and 2001 we entered the semi-presidential system of government. Croatia adopted a parliamentary one, but with still elected president of the Republic. And in 2001 this reform was basically completed because with abolishing of bicameral parliament.
Bicameral.
Yes, exactly. So the Hrvatski Sabor, Croatian parliament, starting from 2001, is a unicameral body. And then we come to 2010. In 2010, Croatia adopted constitutional changes which whose primary aim was to prepare country and its legal system for entering the European Union. So to enable for the legal system to function in this EU legal framework, it was necessary to adopt some new arrangements, provisions in the constitution. So basically the constitution was changed in a way that its new part on the European Union with altogether 4 provisions was adopted.
So there is a new chapter or a new title.
Exactly, there is a completely new chapter in the constitution, which is called European Union. And if you compare this part of the constitution with constitutions of other member state countries, especially new democracies, then you will find many similarities. This part of constitution had to provide a room for direct effect of EU law. It also had to arrange the participation of the Republic of Croatia in the institutions of the European Union. Of course, rights of EU citizens and Croatian citizens as now EU citizens had to be incorporated and arranged as well.
Dear Professor, you already mentioned 2 times the concept of new democracies. And if I can provoke you, I always denied this kind of dichotomy, being old or new democracies. Looking back only to the Hungarian constitutional development, we already had a golden bull in 1222, and I do know that also in the Central European region, also in your country, there already existed documents of rule of law, which among many provisions established the jus resistendi, which is one cornerstone of the right to resist the power when it's acting against the fundamental principles. So I don't know if it's just because in the constitutional science this concept of new democracies or developing democracies is often used, and this is why also used.
You are right. I use the term new democracies primarily as a well-accepted term to denote ex-socialist countries that after 1989-1990 began to develop new constitutional arrangement of society after 45 years of communist era of socialist experience. However, it is just to oppose to Western democracies which are described as well-developed democracies. However, you are right that we also have many things to be proud of in that segment. I will just mention an example from one of Croatian beautiful islands. You know that Croatia is known as a land of 1,000 islands.
How many? 1,180?
Yes, you are right. I don't know precisely. I must admit, but it's more than 1,000. Of course, these are big islands, populated islands, unpopulated islands, reefs, etc. However, one of those islands is the island of Korčula, for which I have special connection. First of all, my personal connection with Korčula is strong because my grandfather and grandmother were born and raised on the island of Korčula, and that is my summer resort. But when I think of legal profession, then I must say that already in 1214, the Statute of Town and island of Korčula was issued or was adopted. And what is important...
Acknowledged or...
acknowledged.
Recognized.
Yeah, recognized. But it was adopted by the local commune.
Okay.
And what is important for that legal document is the fact that it is in fact a legal monument, because it is the oldest statute of any Croatian commune or among the Croatian people, and it is only second to Russian justice, Ruskaya Pravda, which was adopted in 11th, 12th century. We can also compare it with some documents of the time, such as Magna Carta Libertatum that you've mentioned. The whole world rightfully knows for
1215.
1215. Magna Carta, its 800th anniversary was celebrated all around the world. However, documents such as the Statute of Town and Island of Korčula have many similarities to Magna Carta Libertatum, and we can with reason be proud of documents such this, or Vinodolski Zakonik, or other, or Hungarian Golden
Bull, yes, from 1222.
Yeah, exactly.
Just 7 years after Magna Carta. We just had a big national jubileum for that on the 800th anniversary. And there are already the blueprints for democracy, rule of law.
Exactly, because these are rudiments of the rule of law. But you will not find them only in Magna Carta. You will find them also in Korčulanski Statut as well. You will also find some provisions that can be seen as traces of modern guarantees of human rights and fundamental freedoms. Of course, they were made in completely different time, and we have to compare them. We have to do that with reserve, and we have to do it cleverly.
Or in the essence, we have to compare.
Exactly,
those
but
rights.
this is a proof that a small Dalmatian commune was part of wider European humanist tradition already in that time.
Thank you very much for these thoughts, because this is also what the Central European Academy can be proud of, that we do know ourselves, and we would like to make an impact on our Western colleagues, and we would like to be heard and be visible with our historic achievements as well. And thanks to these professors' network, we can publish books, we can publish studies, theses, so that they get to know us better.
Absolutely, and I would say that exactly the projects of Central European Academy can help each of our nations to put in the first plan our national identities and our national peculiarities. We are all part of the same Europe, we are all part of the same community, but we have our strong national identities, and that is something that we have to be proud of. So yeah, maybe when we talk about some peculiarities of important for Croatia and Croatian constitutional law, one of the facts is connected with the constitutional adjudication. We are all aware that judicial review, or this constitutional adjudication, was in a way born in the United States of America after 1803, a landmark case, Marbury versus Madison, Supreme Court led by Chief Justice John Marshall. Or later in Europe, when in 1920s, the first constitutional courts were created in Austria, Czechoslovakia, under the model of famous Austrian lawyer Hans Kelsen. It is also well known that socialist countries did not have constitutional courts. Well, Croatia gives a different example. This is something that is very interesting for the world of socialist constitutionality, because Croatia, of course, at that time, as integral part of the Yugoslav Federation, so it's a situation that mirrors for all of those states, got its constitutional court already in 1963. That court became operational a few years later. It is true that it never managed to acquire any significant role in the political system of the time, that cases heard before it were of minor political importance, but still it is the fact that Croatia has a long history of constitutional adjudication. Then in 1990, when Constitutional Court was created, it got I would say real renowned competencies for constitutional courts, such as constitutional review of laws, constitutional review of constitutionality of laws, review of legality of laws and other regulations, even constitutional complaints, which is something of a novelty. But still, this tradition of constitutional adjudication exists back from 1960s.
Let's move on to the national parliaments and the European Parliament, because this is the topic which I identify with you the most when you come to hold presentations or hold workshops for our students. And if I recall, Nikolina is also making a PhD research on the national parliament. I myself I was chairwoman of the Hungarian in the National Assembly, in the Hungarian National Assembly of the European Union Affairs Committee. It was a great adventure, seeing the functioning of national parliaments and the participation of the national parliament in the European legislation. We have these yellow card, red card procedures, which require a lot of effort, and sometimes, or most of the time, unfortunately, without real political impact on the European legislation. So we would also go through these steps or these features of the national parliaments. So just please, based on your research, can you just tell me how do you assess the impact of the EU membership on the Croatian parliament's internal procedures and the legislative culture? The parliamentarians in Zagreb, are they aware of their capability as parliamentarians to affect European legislation? Is it in their everyday routine or thinking that they are linked in to European legislation?
Okay. Well, we might start with the fact that Croatian parliament and its members really did a tremendous job in the process of Croatian accession to the European Union. In this whole process of alignment of Croatian laws with the acquis communautaire, it was exactly the Croatian parliament that
it was the Croatian parliament which had to ratify?
Absolutely. And
be an active participant.
Absolutely, be an active participant in the European affairs. The central body when it comes to national parliament, or the central committee, is the European Affairs Committee, which on one hand scrutinizes the government and its activities in the European institutions, and on the other hand, of course, is its important task is to check the subsidiarity principle. Now, you mentioned the early warning mechanism. I would say that coming to the role of national parliaments in the European Union, the Lisbon Treaty really make a huge step forward when it comes to inclusion of national parliaments into the political life of the European Union. However, checking of subsidiarity principle through the early warning mechanism was something that many expected a lot, but in the end it proved that it didn't.
It's a weak tool.
It didn't happen, unfortunately, in practice.
Yes, a lot of efforts for almost nothing.
Exactly. First of all, it is an instrument that lacks teeth. Second, if we just go through record, I think I'm not wrong if I say that there were altogether three occasions in which that early warning mechanism was triggered, was successful. And it is question, was it successful? Because Commission doesn't have an obligation to change anything. The only obligation of a Commission is to issue a reasoned opinion on its stance. So I do honestly think that the early warning mechanism has real potential in including national parliaments in the functioning of the European Union in its lawmaking process, but in order to be successful, it has to be reformed.
And when you are collecting allies in this early warning procedure, you have to make a lot of efforts in finding friends in the European club. And on the other hand, when there is the appropriate amount of member states, national parliaments, resolutions, still on the side of the Commission, there is no real obligation to amend or change or withdraw that very legislative proposal. How does Croatia collect friends when you really see a problem with infringing sovereignty? Does the national parliament have a good, well-established network already, where they just make phone calls, send emails,
absolutely.
trying to raise attention, or you cooperate with council colleagues to help to find the right channels to lobby for the early warning procedure?
There are well-established interparliamentary connections, and Croatia uses these connections well. I would say that the Croatian parliament overall is an active parliament when it comes to that, but as you mentioned earlier, it's a complex arrangement, and it's not easy to come to the solution. So gaining enough signatures or enough allies in that sense, it's not easy.
It's not easy. And the lege ferenda, do you see any proposal in order to reform either the domestic part or the European Union part in order to make it more effective?
Absolutely. In my opinion, the real reform has to be done at the EU level. We already have orange card and red card. And
let's have a blue card.
Yeah, let's have a blue card. There are proposals for green card. This is an instrument that has potential, but has to be reformed at the level of the European Union.
Yeah, I completely agree. I experienced it with my own eyes while being a chairwoman of the Hungarian European Affairs Committee in the National Assembly. Do you see the Croatian Parliament successfully balancing the national sovereignty with the compliance with EU legislation? If there's an issue, for example, there's a directive where there is a room for maneuvering during the transposition exercise to safeguard sovereignty to the fullest extent. Is the national parliament partner in this, or it is split based on political wings?
No, I would say that national parliament is a partner in the whole process. There is always room for maneuvering, but on the other hand, when transposing directives, there is no that much room in the end, because otherwise we wouldn't achieve one of the main goals, which is attaining legal certainty.
Attaining legal certainty. Could you please elaborate on that? What do you mean by legal certainty in this context?
In order for the EU law to be successful, it is necessary that it can be applied pretty much in the same way throughout the whole member states. This is legal certainty I was thinking about.
Yeah, one element of rule of law. Also, my personal experience in Brussels lawmaking was a bit pessimistic about that legal certainty. Just looking at the procedure, how a European legislative act is being born, already the the genesis is quite complicated, because on one side we see the 27, 28, the time member states having to have a compromise on a very long text regulating chemical materials, for example. Everybody has their own industrial aspects, interests, etc. They have to find a common wording already in the Council. On the other hand, we have the European Parliament, which is split according to political directions, but also in the background, national interests are still having a say on the European parliamentary side. And then throughout the trialogue talks, they have to come to a conclusion also with the parents of that baby, of that regulation, the European Commission, who were drafting the proposal. So if we take an example from the reality, like a regulation on chemical substances, which are in itself a very complicated text and content-wise quite a challenge to understand, then when the final compromise is being made, nobody understands at the end. And then each member state has a deadline to transpose it with all the specificities of their own industrial interest. So at the end, we have 1,000-page guidances how that European legislation, that directive, should be implemented. And I did not mention at this stage the language challenge, the language chaos. Sometimes I took an example of one directive, one sentence, how it was then translated in the final product, let's say in the transposed national legislation. Already those linguistic interpretations raised many, many questions. And who is at the end of this whole process? The stakeholder who has to implement it, maybe with the burden of a sanctioning method. If they don't comply with this legislation, they will be fined, etc. So it's not easy to have this legislation put through the channel, so that still at the end everybody understands what we are talking about. Do you see here, like a private person, like being a citizen of the European Union, do you see here a reasonable method how we could just simplify this procedure, giving more voice to national parliaments, so already the proposal has more reality based on the member states' needs, and then channel in the national parliament's opinion into this legislative process? Or on the other side, or on the other hand, would this even make this more difficult or more complex?
No, I would say that the only solution is simplifying the whole process and giving the national parliaments much more decisive role in the whole process. However, taking into account the complexity of the European Union, it's not an easy task, and taking into account also the fact that hopefully the European Union will widen its membership in years to come. That will be maybe even harder to realize in years to come. That is why we should start tackling that problem now.
It was not among the question which we discussed earlier, but I'm really curious, and up to you to answer these questions about the enlargement, because Croatia is a neighboring country of the West Balkan countries who are candidates for many years. Do you have a special Croatian view on enlargement? I know from the policy point of view that Croatia is a long-standing supporter of the enlargement procedure of the West Balkan countries. It's obvious not only for economic or social reasons, but also for neighborhood reasons. So do you have any special thought on that? How this process could be accelerated, could be more successful? Because it's getting quite frustrating for the whole European Union that these countries are in the corridor for many, many years, and maybe losing hope or losing impetus, losing momentum.
Absolutely. So Croatia has been supportive when it comes to the question of enlargement of the European Union to the Western Balkan countries. We are all aware that the process that Croatia went through was really a complex one, it took very long. It took 11 or 13 years to be completed. And what to say when we think about Western Balkan countries such as Macedonia, who maybe had the best pole position back in 1990s.
And already changed the constitution, changed the name of the country.
They have changed the name of the country, they have changed their constitution. So I would say that it is only natural that the idea itself will, with time, lose support among the citizens, among the people. However, the European Union has no other future but to continue with the enlargement. When it comes to Croatia, I would say that it is in our best national interest that all our neighboring countries sooner than later become new member states of the European Union. In that sense, I'm very glad that Montenegro has made significant progress in recent years.
Actually, the same from the Hungarian side. We are also long-standing supporters of the accession of the Balkan countries. So we do hope the best for the future. We are coming to the final part of this discussion, and you are a teacher at the university, and you also meet your students and you see their professional career wishes. If they choose constitutional law, like you have chosen this many years ago, in which direction would you recommend them to start today? What are the best topics, most charming challenges in this field of law?
Yeah, well, to start with, I would always recommend students to enroll at law studies, because it offers you a variety of choices. It goes especially for disciplines such as constitutional law. Constitutional law, on one hand, tackles some of the most important questions and dilemmas for state and for its citizens. On the other hand, it is a discipline that combines not only law, but also history, political science, etc. That's what I like the most when it comes to constitutional law. What are hot topics? This is something that is changing. There are some classic topics. I would always say that human rights and fundamental freedoms, because of their importance for each individual, is the topic that deserves to be elaborated further.
In more depth.
Yeah.
Dear Professor Bačić, we are always playing a game with our guests at the end of the discussion. Today you are representing your country, Croatia. And if you had only one chance in life to say 5 truths or refuting misconceptions about your country, what would this be? What would you tell us about your country if I didn't know your country?
Okay. When I travel, and I travel a lot, when I get into conversation about Croatia and what is Croatia famous for, you will usually find that people know for excellent Croatian football players, which is true, or the fact that Croatia is a very popular tourist destination. That is all true, but I would somehow like it was a little bit different. Maybe if I could change that perception, then I would like Croatia to be recognized for some remarkable persons or famous scientists, and there have been many throughout Croatian history. I will try just to name few. For example, my first idea would be Ruđer Bošković, born in Dubrovnik. He was a physicist. He was specialized in mathematics. He also elaborated atomic theory that predated later atomic models. He was founder of Brera Observatory in Milano. Even my elementary school used to have his name. Or other person would be Faust Rančić, born also in Dalmatia, in Šibenik. He was also a remarkable person. He was not only polymath, not only scientist, he was also inventor. He wrote a book, Macchine Nove, which basically predated many achievements that came later, such as suspension bridges, or he is the one who invented the first parachute. He called it Homo volans, or flying man. So it's not that Croatia shouldn't be recognized when it comes to excellent football players.
Luka
yes.
Modric.
Yeah, Luka Modric. It's great and others.
But there are the scientists.
Exactly. It's great to score goals at World Football Championships. It's also great to be recognized when it comes to some inventions like a necktie. Tie or cravata, that is also a Croatian invention, but I kind of like it that it was in backstage, and these persons, some of them I refer to, maybe are mentioned more.
Professor Bačić, thank you very much for being with us, and we do hope that we cooperate a lot in the future, and you keep sending good students from Split University to the Central European Academy. Dear ladies and gentlemen, thank you very much for being with us. We were discussing the constitutional identity of Croatia, also the concepts of federalism, with the participation of our guest, Mr. Petar Bačić from the University of Split, Croatia. Please follow us on the social media. Thank you very much.
We hope you enjoyed this episode of Central European Legal Insights. Don't forget to follow us on our social media channels for updates. To discover more conversations from the series, be sure to explore our other episodes. Thank you for listening.